I saw a debate about the Charlie Kirk murder, and one of them said if the defense had evidence that proved the guy was innocent, they would have presented it at the preliminary hearing. As a criminal defense trial lawyer who actually does trials, I will tell you that is not what a preliminary hearing is for. At a preliminary hearing, a judge isn't deciding whether the defendant is guilty beyond a reasonable doubt. The judge is deciding whether there is enough evidence, probable cause, to make the defendant stand trial. That is a much lower standard. If there is a reasonable possibility he was the shooter or assisted the shooter, the case against him is moving forward. So if I'm the defense lawyer and I already know the prosecutor has enough evidence to get past the preliminary hearing, why would I show them my best exculpatory evidence? What would that accomplish? Maybe nothing, except telling the prosecution exactly how I plan to beat them. Now they'll know the weaknesses in their case, they'll know what evidence I have, and have months to investigate it, coach their witnesses, and figure out how to deal with it. I've defended cases where I had evidence or a defense I knew would win the case, and I intentionally kept it to myself at the preliminary hearing. Why? Because I don't need to win the preliminary hearing. There's almost no winning the preliminary hearing. I needed to win the trial. So when a defense lawyer doesn't reveal their best evidence early, that doesn't mean they don't have it. Sometimes it means they're saving it for when it actually matters.